Welcome to the polity related current affairs which came in the month of July 2025. Okay, we are going by subject wise current affairs, month wise current affairs. Okay, we have completed June and we are in July 2025. There are some topics which came from polity perspective in July 2025. Most notably, interstate river water dispute. This came in the news. Interstate river water dispute in India. See, the main problem connected to interstate river water dispute is that when a state is reorganized, it is based on linguistic grounds. From 1956, we have State Reorganization Act, and the states were divided. The states were demarcated based on cultural grounds, not based on the grounds like water. Why? Because the water cannot be apportioned like land. Land can be easily demarcated, but what about water? So that is why the water dispute becomes a pertinent dispute between the states of India. So far, there were 9 interstate river water tribunals constituted. We have a mechanism to resolve the interstate river water dispute called as Interstate River Water Dispute Act 1956. Based on this Interstate River Water Dispute Act, we have so far constituted 9 interstate river water tribunals. Out of this 9, 5 have given their award, and after giving award, it has to be dissolved. 4 still alive. 4 are still alive. So what are the 9 interstate river water tribunals which were constituted from 1956 onwards? The interstate river water dispute tribunals constituted so far. Number 1, Godavari. Number 2, Krishna. Number 3, Narmada. And these 3 were constituted in 1969. And then we have the 4th one, Ravi Dias, which came in the news. 1986. So this only was in the news recently. We'll have a discussion on this. Then fifthly, we have Kaveri. Then sixthly, we have Krishna too. Seventhly, we have Vansadhara. Eighthly, Mahadai. and ninthly Mahanadi. So these were the 9 rivers which were in the dispute amongst the states sharing these rivers. And Godavari, Krishna, Narmada, Ravi, Bias, Kaveri, Krishna to Vansadhara, Mahadayi and Mahanadi. 4 are still alive. For example, Ravi Bias is still alive. Then Krishna 2 is still alive. Mahadayi is still alive. Mahanadi is still alive. So 4 rivers have not been resolved. 4 river disputes have not been resolved, and these are the 4 which are still alive. So why interstate river water dispute came in the news? Because the Ravi Bias Tribunal gets an extension. It is getting an extension. Another 1 year, the period of the tribunal gets extended, which is why it came in the news. Right? So why it came in the news? The Ravi Bias Tribunal has got an extension of 1 year. It will be having the period till 2026. And secondly, why interstate river water dispute was in the news? Because of a flashpoint between Punjab and Haryana with respect to Bakra Bias Management Board's decision. Bakra Bias Management Board's decision. What is that decision? Haryana was asking 4,500 cubic seconds of water extra from the Bakra Nangal Dam. So, Bakra Dam is in Himachal. Nangal Dam is in Punjab. Now, Punjab is refusing to open the water from the Nangal Dam. It is not ready to accept the Bakra Bias Management Board decision to give extra 4,500 cubic seconds of water to Haryana. Why Haryana is requiring water? It says we are having so much of scarcity of water for drinking. Even for drinking, we have a scarcity of water. So we wanted for the next 8 days additional 4,500 cubic seconds of water, which Punjab says strictly no. In fact, Punjab is stationing its police force in the dam, preventing the Bakra Bias Management Board officials to come and open the dam. So there is a standoff between Punjab and Haryana. This Bakra Bias Management Board was constituted by an act of the Parliament, State Reorganization of Punjab Act 1966. An act called as Reorganization of Punjab Act, State of Punjab Reorganization Act, Punjab Reorganization Act 1966 created this Bakra Bias Management Board. What is the function of the board? The board's function is to ensure equitable distribution of the Bakra Nangal Dam water to all the 3 states, Punjab, Haryana and Himachal. So Punjab, Haryana, Himachal will have to have equal sharing of the water. Bakra Nangal Dam is housing whose water? Which water? Bakranangal Dam on which river? Bakranangal Dam on which river? Satluj Dane. So what are the other developments for which it came in the news? The center is constituting a technical committee for Pollavaram project. Why Pollavaram project came in the news? Because the new Chief Minister Chandrababu Naidu says the year of completion, the completion of Pollavaram Dam should not be December 2027, it should be preponed. So he is telling that Pollavaram Dam should be completed by July 2027, not December 2027. Pollavaram Dam is a national project. The central government is giving fund for this project. Pollavaram Dam is a national project. The central government so far has given 20,000 crores to the construction of this dam. But what is the fear which is expressed by the states of Odisha and Chhattisgarh? Pollavaram Dam, fear expressed by the states of Odisha and Chhattisgarh that many of their villages will be submerged under water and many people will have to be relocated because of the dam project. Many people, tribal people, will have to be relocated. So if you relocate them without any adequate compensation, rehabilitation without adequate compensation will result in huge displacement related problems. This is a very big problem we have today. The farmers, the tribals are protesting against the dam projects because it will lead to involuntary and forced displacement. Forcefully, they will be displaced from their own habitation in the name of dam projects. You know that a study says out of 100, 40% of the victims of the dam projects are tribal people. 40% of the victims of dam construction causing displacement is tribal people. Their total population is only 8%, but they are displaced in terms of 40%, which means disproportional to their population, they are suffering from displacement due to the dam projects. So that is why what these states are telling, Odisha, Chhattisgarh says, we are fearing submergence of our villages because of the Pollavaram Dam. And the state governments of Odisha and Chhattisgarh have told that they will amicably settle the dispute connected to Mahanadi. They will have an amicable settlement of the dispute connected to Mahanadi. So there are three important current affairs connected to the interstate river water dispute. One is the extension of Ravi Bias tribunal by another 1 year till 2026. And the Bakra Bias management decision is rejected by Punjab. And Pollavaram Dam should be constructed completely by July 2027, says the new Chief Minister Chandrababu Naidu, rather than December 2027. And this is causing fear in the states of Odisha, Chhattisgarh, especially in the minds of the people who are in the village, tribal people in the village. Right? Now coming to a detailed scrutiny of the interstate river water dispute. Indus Water Treaty. 1960 was signed between Pakistan and India, and it was brokered by World Bank. World Bank only brokered this interstate or Indus Water River Treaty. According to this treaty, the west flowing rivers will go to Pakistan and the eastern rivers will go to India. East flowing rivers are Sutlej, Ravi and Bias. West flowing Indus, Chenab, Jhelum. Okay. In 1981, the three chief ministers, they signed an agreement. 1981, the CMs of Punjab, Haryana, Rajasthan, they signed an agreement to build the Sutlej Yamuna link. It's a canal, Sutlej Yamuna link canal, to transfer water to Haryana. Transfer the water, Ravi Bias water to Haryana. So it was another agreement signed in July 1985 between the Prime Minister of India and the President of the Shiromani Akali Dal. His name is Longowal. Agreement. And this agreement says this Sutlej Yamuna link will be completed by 1986. It will be completed by 1986. And they are even giving the month, August 1986 will complete this. Subsequently, 1986 only, Ravi Bias Tribunal was constituted under this 1956 Act. Interstate River Water Dispute Act. 2 years after this, or 1 year after this, 1987, an initial report was prepared by the tribunal, but all the parties challenged this initial report under Section 5, Clause 3 of the 1956 Act. So even now they have not finalized the award. And this is one of the main problem we have today to resolve the interstate river water dispute, that it takes so much of years for you to solve the interstate river water dispute. For example, Kaveri water dispute, 1990 tribunal was constituted. It took 28 years to solve the problem, to give an award. It took 28 years to give an award. So much of time delay in resolving the interstate river water dispute. The main issue now is Sutlej Yamuna link canal, because Ravi Bias dispute is hampering the Sutlej Yamuna link construction. Sutlej Yamuna link. It is a 214-kilometer canal. (92 kilometer in Haryana and 122 in Punjab. Haryana has completed the construction, but Punjab has not completed the construction because it is not ready to give water to Haryana. Supreme Court came and told in 2000 that Punjab should complete. Punjab must complete its portion. But 2004, Punjab Assembly passed Termination of Agreement Act. Punjab Assembly passed this Termination of Agreement Act, which is unilaterally terminating all the river water agreements which it has agreed. We are unilaterally cancelling all the water sharing agreements. Who says? Punjab Assembly in 2004 says. Or 2016, what happened? The SC declared that Punjab's act is unconstitutional. Punjab's act is unconstitutional. And it has upheld the rights of Haryana. By upholding the rights of Haryana, Supreme Court says Punjab's act, which unilaterally terminates all the water sharing agreement, is unconstitutional. Now, what Punjab Chief Minister says? He proposes to stop the Sutlej Yamuna link canal. Stop SYL project. Instead, divert Chenab River. Chenab River belongs to whom according to Indus Water Treaty? Pakistan. But why Punjab CM says we can divert this Chenab River to feed Haryana? Because post Pahalgam terror attack, India has suspended the Indus Water Treaty unilaterally. But if you wanted to see the text of Indus Water Treaty, it clearly says no unilateral suspension of the treaty. But despite of this, India has declared that we are suspending the Indus Water Treaty. The hydrological leverage India has with the vis-a-vis Pakistan, it wanted to use that hydrological leverage as a tit for tat for the actions of the terrorists who killed the Indians in Pahalgam. Punjab from the beginning says we are the primary riparian state. We are the primary riparian state. What do you mean by riparian? the land owner, the owner of the land which is surrounded by the water body. The owner of the land bordering the river is called as riparian. We are the primary riparian. We are the owner of the land surrounding the river. And this riparian right is recognized in the Indian Easement Acts 1882. Indian Easement Act 1882 accepts this riparian rights. The primary riparian right accepted by Indian Easement Act 1882. But you know that this riparian right is subordinated to the parliamentary law. So Parliament has passed a law called as Interstate River Water Dispute Act 1956, Interstate River Water Board Act 1956. So therefore, your riparian right is not absolute, though it is approved by the Indian Easement Act 1882. Your riparian right is not absolute because the right is subordinated to the parliamentary law. The right is subordinated to the Constitution, especially Article 262, which only deals with the interstate river water dispute. Okay. So what is the issue? The issue is Punjab says we don't have even a drop extra to give to Haryana. We are water stressed state. We don't have even a drop of extra water to be given to Haryana. We are water stressed state. So we can't give any water. Now we have suspended this Indus Water Treaty. Chenab River is not Pakistan's now, it is India's now. So we can divert the Chenab River to feed the states of Haryana. You don't touch my water. Okay. So this is what is the story behind this Punjab Haryana water dispute, Ravi Bias Tribunal, Punjab Haryana flashpoint. Right. Now go to the next one. We said no, all these things we said. The core issue is that they are wanting Chenab to be diverted. They don't want to give even one drop of water. And this board has been constituted by this act. And we have also spoken about how Satluj Yamuna link is a problem because Punjab is fearing their southern districts will be deserted if they give water to Haryana. Okay, so this is what the story which we have already told. Now, what is the main reason behind water crisis? Groundwater is getting depleted so much. So much. Why groundwater is getting depleted? Because agricultural pattern is demanding more water. For example, paddy cultivation is demanding more water. For example, green revolution is demanding more irrigation facilities, more water. And excessive pesticides, excessive fertilizers used is also contaminating the groundwater. And climatic factors. So monsoon failures, no adequate snowfall in Himalaya. And these are the main reasons why the water crisis is looming very large. Now, some articles connected to interstate river water dispute. The 7th schedule provides for 3 list, state list, union list and concurrent list. Water sharing is present in entry number 17 of state list, entry number 56 of union list. And we know Article 262 clause 1 says what? Parliament by law will provide for resolution of interstate river water dispute. That is why Interstate River Water Dispute Act was enacted in 1956 when the problem started with the linguistic reorganization of states. And 262 clause 2 clearly says Parliament by law can exclude any court including Supreme Court. It can exclude any court including Supreme Court from the jurisdiction of interstate river water dispute. That is why this act itself says Supreme Court cannot enter the resolution of the dispute. But remember that Supreme Court does not have original jurisdiction. It can have appellate jurisdiction. No original jurisdiction for Supreme Court under Article 131, but you can approach through writ under Article 32. You can approach through SLP under Article 136. This is available. Only 131 is not available. So the tribunal's award can be interpreted by the Supreme Court. That the Tamil Nadu government wanted the Kaveri water dispute award given by the tribunal to be interpreted by Supreme Court and filed special leave petition before the Supreme Court against the order of the tribunal. Okay, so these aspects you need to know. These aspects, 131 is not available, but writ is available, SLP is available. So the reason for the persistent problem, geographical asymmetry, upper riparian states have control over the water. State reorganization cannot divide the water. Division of water is not possible like division of land. Fragmented governance. We have ad hoc tribunals. And water becomes politicized. It becomes an election matter. Data vacuum. No data on annual rainfall. No data on the water demand. We don't have a comprehensive database. That is why there is persistent dispute emerging. What solution you can give? What can be the solution? There can be a national data bank on water. There should be proper demand management. And more expansion of micro irrigation. PM Krishi Sinchai. Micro irrigation. And technological solutions like scientific aquifer mapping, scientific aquifer mapping and recharge. These are some of the solutions. Now, a legal attempt was made to create a permanent tribunal. We wanted to create a permanent tribunal rather than ad hoc tribunal. Let us have a permanent tribunal. So it was in 2019 that there was a bill moved in the parliament for creating a permanent interstate river water tribunal rather than ad hoc. So this permanent tribunal mechanism provides for a two-tier resolution. There will be a dispute management committee which has to give the solution within 1 year, which can be extended by 6 months. If this is not doing it, if this is failing, then only you go to the permanent tribunal. So there is a time bound resolution of dispute that maximum 4.5 years will be the time available for the resolution of the dispute. The award should be given within 4.5 years maximum. How many years it took for the Kaveri Tribunal to give award? 28 years. When 1986 Ravi Bias Tribunal was constituted, even now it is not getting resolved. The tribunal could not give the award. So much of delay in the award is the main problem. Even when you give the award, it takes so much of time for you to publish in the Gazette. After publishing in the Gazette only, 3 months after publication of the award in the Gazette only, the award comes into force. They are not publishing the award in the Gazette so that it cannot be coming into force. Award may be given, but when it can come into force? Only if it is published in the Gazette. 3 months after the publication in the Gazette only the award comes into force. Award given, but don't publish in the result so that the award cannot be coming into force at all. But this solution that we will have a permanent interstate river water dispute tribunal could not be done because the bill lapsed due to 2024 election. Okay. After the publication of the award in the Gazette, the award will be like the judgment of the Supreme Court. That is why you cannot challenge in the Supreme Court under original jurisdiction. You cannot bring the river water dispute into the Supreme Court because the award itself is like a Supreme Court judgment. Okay, so this is about the interstate river water dispute which came in the news. Now the second topic is the removal of the judges. Removal of the judges. Justice Verma, who was the High Court Judge of Delhi, so many burnt caches were found during the Holi celebration. His house got fire, and an estimation, a rumor says 100 crores money was there in the house of the High Court of Delhi's Judge Verma. So the Chief Justice of India told Justice Verma to resign, but Verma refused to resign. which is why the removal process got initiated. So this is why it came in the news that the removal process against Justice Verma of Delhi High Court got initiated. That is why it came in the news. Justice Yashwant Verma, following judicial panel's indictment that sacks of burnt currency was found in his residence. The conflict is what? CJI versus Verma. And parliamentary action under Article 217, which is as same as Article 124. Some constitutional provisions. 124, removal of Supreme Court judge based on two grounds: incapacity or proved misbehavior. One 124 clause 5 says procedure regulated by parliamentary law. So Judges Inquiry Act 1968 came, stipulating how to remove. 217 says removal of High Court judge is same as that of 124 clause 4, and this says 124 clause 4 and 124 clause 5 applies to High Court judge also. These are the constitutional frameworks. Okay. So how it is happening? The first stage is the initiation. Hundred MPs if the resolution is introduced in Lok Sabha, 50 MPs if the resolution is introduced in Rajya Sabha, according to Judges Inquiry Act. Investigation. The introducing house, presiding officer, it can be either chairperson of Rajya Sabha if introduced in Rajya Sabha, speaker of Lok Sabha if the resolution is introduced in Lok Sabha. They constitute a judicial inquiry committee. It should be a 3-member committee which should consist of the Judge of Supreme Court, Chief Justice of High Court, and an eminent jurist. So, if the committee says that the charges are proved, then it will be taken by the parliament for voting. The first house will vote by special majority. That is 2/3 present plus voting plus half of the total strength of the house. Then the second house also will have to pass by a special majority. Then a joint address of both the houses will be given to the President of India in the same session. In the same session. And now President will remove the judge. Removal order will be passed by the President. This is the procedure which is given in the Constitution and the Judges Inquiry Act. Just recalling your Indian polity. Okay. Now what is next? the past history of the removal attempt. So far, there is no single judge who was removed. The first case is Ramasamy case. 11 out of 14 charges. There were 14 charges leveled against Ramasamy, and the inquiry committee found that 11 out of 14 charges are correct charges. The committee found him guilty of the 11 out of 14 charges. But he could not be removed because the ruling party Congress abstained from voting. Then we have Justice Soumitra Sen. Justice Soumitra Sen. The removal was passed by the Rajya Sabha. Removal resolution was passed by Rajya Sabha. The first judge against whom a House of Parliament has passed a resolution is Soumitra Sen only. But before it went to Lok Sabha, he resigned. Justice Dinakaran on corruption charges. He resigned before the process started. He resigned because he wanted to get all the retirement benefits. So he himself resigned. When he is resigning, the cases also will be dropped. அப்போ என்ன பண்ணணும்? ரிசைன் பண்ணுறது தான் பெஸ்ட். ஜஸ்டிஸ் தினகரனை பற்றி வந்துச்சு. ஜஸ்டிஸ் தினகரன் டிட் நாட் பை ஹவுசஸ். அவர் வீடெல்லாம் வாங்கலையாம். ஜஸ்டிஸ் தினகரன் கிரியேட்டட் தினகரன் நகர், ஊரையே உருவாக்கி இருக்கிறார். ரிசைன் பண்ணோன்னா டிராப் பண்ணிட்டாங்க சார்ஜஸ். The next is what? Then we have others like Deepak Mishra. Deepak Mishra, the then Chief Justice of India, but the chairperson rejected the removal resolution. It could not be introduced. Deepak Mishra. And the fifth person is Verma. More than 140 MPs in Lok Sabha, they have signed the resolution. Okay. So this is about the removal of judges. Then go to the next topic. National Cooperation Policy was announced. National Cooperation Policy was announced. So it will be a roadmap for the next 20 years from 2025 to 2045 to make cooperatives more vibrant. So the Ministry of Cooperation says they are the first new policy in the last 2 decades to revitalize the cooperatives. And this cooperative policy aligns with that of the UN International Year of Cooperatives. 2025 is dedicated to cooperatives by United Nations. It is called as UN Year of Cooperatives. And the theme is Cooperatives Build a Better World. This is the theme. So in sync with the tune of or the theme of this UN decade, UN Year of Cooperatives, we have unveiled this policy. Okay. So these are the 6 pillars of the policy. 6 pillars. And the vision of this policy is prosperity through cooperation. Sahakar se Samriti. Prosperity through cooperation, the vision of this national cooperation policy. These 6 pillars are strengthening the foundation. You will create a proper legal basis for strengthening the foundation. Legal reforms. Example, legal reforms. And the second is promoting vibrancy through building supportive ecosystem. And market linkages. Future readiness integrating with artificial intelligence. Inclusivity including women, youths, SC/ST. New sectors are included like the clean fuel, clean energy, waste management, insurance, hospital. New areas which were not taken up earlier by the cooperatives will now be taken up. And capacity building by skill education, skill sets, skill training. So these are the 6 pillars outlined by the National Cooperation Policy. What is the constitutional status of cooperatives? Article 19, 1C, Article 43B, and Part 9B, Article 243, ZH2, 243, ZT deals with cooperatives. So right to form cooperative is a fundamental right. Cooperatives, associations, right to association and cooperatives, which was inserted by 97th Amendment Act. Similarly, voluntary formation, democratic professional management, democratic functioning, professional management of cooperatives. Says Article 43B, the state will have to take steps for voluntary formation, democratic functioning and professional management of cooperatives, and this also was inserted by 97th Amendment Act. Part 9B from Article 243 ZH to 243 ZT speaks about the incorporation of cooperatives, the regulation. It speaks about incorporations, election, 5-year board terms, five-year term, audit, all these given by these provisions of the Constitution. Similarly, entry 32 of state list. Entry 32 of state list and entry 44 of union list. Also speaks about cooperatives. This speaks about multi-state cooperatives. So right to form cooperative is a fundamental right. Voluntary democratic functioning of cooperative is a directive principle of state policy. Election 5-year term comes under part 9B, and there are present state list, central list entries 32 and 44 connected to cooperatives. Okay. What are the challenges of the cooperatives? There are 8.5 lakh cooperatives involving 30 crore member. Now the target they are setting is we will include 50 crore by 2030. The PACS, Primary Agricultural Credit Society, it accounts for 20% of the total agricultural credit in India. 35% of the fertilizer distribution is done through this IFCO, Indian Farmers Fertilizer Cooperative, and 30% of the sugar production, 10% of the milk production is through cooperative. They wanted to make that instead of 50% of milk, 10% of milk production from cooperative, target is 50% of milk production should be from cooperative in the next 2 decades. So challenges are what? Most of the cooperatives are in Maharashtra, Gujarat, Karnataka and Tamil Nadu. In other states, cooperatives are not picking up because of political interference. Too much of political interference reduces the autonomy of the cooperatives, lack of professionalism. So many of the primary agricultural credit societies lack trained personnel and modern technology. In fact, what the policy says, the policy 2025 says that we will create multi-purpose PACs, which will involve in 25 plus new activities, new business activities, like generic medicines, like e-commerce. So they are involving, according to the policy 2025, they wanted the PACs to take up 25 new types of activities. But the PACs are having lack of professional expertise, and that is why these are the challenges of cooperatives. Cooperative, actually you should understand the ideology of cooperative is this. We are in between these two models of economy. One model of economy is the Western capitalism, completely go for capitalism. The other model of economy is completely you go for communism. Neither we have 100% capitalism nor we have 100% communism. We are in between. Pandit Nehru says democratic socialism, which means we wanted a mixed economy, not this or that. We wanted elements of both, and that is why cooperatives will be a middle path between capitalism and communism, which is why cooperative becomes very, very important for our economy. So revitalization of cooperative therefore is going to happen because of this policy for the next 20 years. Now the fourth topic for today is OCI scheme. The Prime Minister of India in July 2025 visited a Caribbean country called as Trinidad and Tobago. Here he is announcing some concessions. He is making some extensions with respect to OCI, which is why it came in the news. The Prime Minister visit in July 2025 to a Caribbean country called as Trinidad and Tobago. You know, this is a very, very important country because 40% of people in this country belong to persons of Indian origin. During the British time, what happened in 19th and 20th century? Many indentured laborers were shipped from India to Pacific colonies, Caribbean colonies by the British colonial masters. In 1845, a set of indentured laborers entered Trinidad and Tobago in 1845. So, the Prime Minister went to Trinidad and Tobago to commemorate the 180th anniversary of this date of the entry of the indentured laborers from India. So, 180th anniversary. There is a term which they are using for the indentured laborer called as girmithia. Girmithia is a term used for agreement. So they agreed to take the indentured laborers to Pacific countries, Caribbean countries. And the first set went to Trinidad Tobago in 1845, which is why it is coinciding with the 180th anniversary of this year. Okay. So Girmithia means they are indentured laborers who were brought during the British colonial rule. Now, what is the concession because of the PM visit? Normally, it will be given for only 4 generations. Now, the PM visit made the OCI card available for 6 generation people. 6 generation people can avail this OCI card belonging to PIO category in Trinidad and Tobago. 6th generation. So far, OCI card will be given only to 4 generations. But because of the PM visit, it got extended to 6 generations. Those who were the children of PIOs, who were the descendants of India before 150 years, they also can avail OCI card now. That is what is the crux of this current affairs. Now, what do you mean by OCI card? In fact, many people of Indian origin, they went to different parts of the world during the British rule as indentured laborers. Okay. And many have become prominent personalities there. They have even become the heads of the states, heads of the governments, people from PIO, people of Indian origin, their descendants have become prominent officers. They have become prominent political personalities in many countries. So India, after 1991 globalization, wanted to give some sort of concession to these people of Indian origin because they have their root in India. Today they may not be citizens of India because we don't allow dual citizenship according to our constitution, but the historical connection, the cultural root which we have with that of PIOs, that has to be respected, for which only in 1999 onwards, from 1999 onwards, PIO card was given. So 1999 onwards, PIO, persons of Indian origin, card was distributed. PIO card was given. So which allows visa free entry for those having this PIO card. No police approval up to 6 months. PIO card holders are not citizens. but they will be having facilities like visa free entry, no police verification up to 6 months. Then in the year 2000, L.M. Singhvi Committee was constituted. It says no need for constitution amendment to give dual citizenship for PIOs, because the PIOs or PIO card holders are those people who were born after January 26, 1950. So if you wanted to extend the citizenship for the PIO card holders, you can do it by amending not the constitution, amend the Citizenship Act 1955. However, the government very clearly said no dual citizenship, because if you see Article 9, it clearly says if you acquire a foreign citizenship voluntarily, if you voluntarily acquire a foreign citizenship, your Indian citizenship will be automatically cancelled. So we don't have in the constitution dual citizenship, but we will give some facilities to the PIOs by giving them a card whereby they can avail some facilities like visa free entry, no police verification up to 6 months. The L.M. Singhvi committee said that let us give OCI card to PIOs of 16 countries. Singhvi only says give OCI card to PIOs of 16 countries. Mostly they are developed countries. OCI card is better than PIO card. Why? Because in OCI card, you need not get any permission. You can stay in India even beyond 180 days without police verification. So it is more giving freedom for the OCI card holders, are having more freedom than the PIO card holders. Simple example, a PIO card holder, if he wanted to stay in India more than 6 months, which means more than 180 days, he has to get the approval of the police. He should inform the police. He should get the approval of the consulate, embassy. But for an OCI card holder, this limit and all is not there. So let us give more concession to the PIOs through a new card called as OCI card. So now OCI card was given to PIOs of all countries since 2005, except Bangladesh and Pakistan. All PIOs staying outside India except Bangladesh, Pakistan will be given OCI card. Since PIO card and OCI card is duplicating the work, in 2015 they merged the cards. OCI card is now available. PIO card got merged with the OCI. Now there is only one category called as OCI card holder. There is only one category called as OCI card holder post merger of PIO card with that of the OCI card. Okay. Now OCI card holder is coming under section 7A, section 7B, section 7C of the Citizenship Act 1955. So OCI card is given under the Citizenship Act 1955 only. Okay. Now let us see what is there in the slide. OCA card does not mean dual citizenship, so it is not a dual citizenship, but you can have a permanent residency status. Why? Because Article 9 prohibits dual citizenship. OCA card was established in 2005 because of the LM Singhvi committee recommendation, and it is governed by the Citizenship Act 1955. PIO scheme was merged with OCA card in 2015. We have already told the nodal ministry governing citizenship is Home Ministry. Census comes under Home Ministry. Citizenship also comes under Home Ministry. Now, who can apply? Historical connection. Children who are the citizens of India by January 26, 1950 and who are eligible for Indian citizenship who were born post January 26, 1950. Direct lineage. So, children can get, grandchildren can get, great grandchildren can get. Minors and spouses. If the spouse is an citizen of India or a PIO card holder and either parent is a PIO card holder or a citizen of India. But you remember that those people who will not get OCI card is those who are citizens of Pakistan, Bangladesh, and those who were serving, those who served or who are serving in the foreign military, they are also not eligible for OCI card. Pakistanis, Bangladeshis, and those who worked or who are working in the foreign military, they are not eligible for OCI card benefits. Strictly no to these two categories. You should not be in the military of a foreign government, and secondly, you should not be a citizen of Pakistan or Bangladesh. Only then you can avail OCI card. So what rights and all they have? Definitely, they have many rights. For example, lifelong multi-entry visa, permanent residency, which means they need not have any registration in the FRFO office. Foreigners Regional Registration Office. Foreigner Regional Registration Office, FRRO. Foreigner Regional Registration Office, no registration in this office. Economic and educational parity, so they can write the NEET exam. Okay. And property rights, definitely they have the right to buy property, but no agricultural property. Any property other than agricultural property can be bought by these people on par with that of the Indian citizens. They can take up any profession. they can practice medicine, they can practice law. Like Indian citizens, they have professional practice. But what we don't have in the OCI card is no voting right, no constitutional post, like you can't become the president, you can't become the vice president, you cannot become MP, MLA, you cannot become the judges of Supreme Court or High Court. And 2021 security rules, if you are taking up journalism, if you are taking up any research, if you are doing some missionary activity, and if you are entering the protected areas, take special permission. Okay, so these are some of the strict rules they brought in 2021. With this, the 4 topics which we found important from polity in the July 2025 current affairs is over. See you in the next current affairs class. Thank you.